changes have been made to the massive tax, including ones that would loosen regulations on gun suppressors.
My Second Amendment deals with to eliminate the $200 tax on silencers.
That would prohibit the sale, transfer, production, and possession of gun silencers.
It's outrageous that they would spend $1.4 billion to make silencers cheaper.
It has been almost a century since the federal government put strict limits on gun suppressors.
It has everything to do with making money for a certain segment of the gun industry.
The whole legal groundwork beneath one of America's most enduring firearm statutes could be collapsing, and the administration has just revealed how it intends to prevent that collapse. An enormous judicial conflict is currently playing out concerning the National Firearms Act, and what recently transpired in this litigation alters the complete direction of the dispute. Those suing to overturn the NFA didn't merely claim the statute was being enforced unjustly. They pushed far beyond that. They introduced a fresh Supreme Court judgment and leveraged it to contend that the NFA might no longer hold constitutional validity. And the official government reply to that contention exposes precisely how frantic and tactical their defense has grown. This is an evolving legal narrative with massive consequences for every gun owner nationwide, and the specifics are crucial here. So let's examine everything that recently occurred. To grasp why this litigation carries such weight, you must comprehend the background of the NFA and the reasons it was created initially. The National Firearms Act has remained in effect since 1934. It governs objects such as silencers, short-barreled rifles, short-barreled shotguns, and a classification referred to as any other weapons for generations. If you wished to legally possess any of these objects, you needed to endure an extended registration procedure, undergo a background screening, endure months awaiting authorization, and submit a $200 revenue. That revenue stamp represents the crux of this entire narrative. When the NFA initially faced judicial scrutiny ages ago, it endured because judges regarded it as a revenue measure. The logic was simple. Congress possesses extensive power to impose levies. The NFA places a levy on specific firearm exchanges. Consequently, the NFA constitutes a legitimate use of Congress's revenue authority. That served as the constitutional rationale. That formed the support, maintaining the whole framework. And for almost 100 years, that support remained unchallenged in any substantial manner. Then, lawmakers enacted something nobody anticipated would generate such significant judicial repercussions. Through recent statutes, Congress lowered the NFA levy to $0 for multiple classifications of objects, including silencers, short-barreled rifles, short-barreled shotguns, and any other weapons. Superficially, this appeared like a victory for firearm owners. No more $200 charge to practice your rights. But underneath, this modification triggered a legal upheaval, because if the NFA was perpetually defended as a revenue measure and now the levy is effectively zero, what precisely sustains the statute anymore? That constitutes the inquiry at the center of this litigation, and each faction offers distinctly different responses. Those bringing the suit have been constructing their argument systematically. Their central claim is beautifully straightforward. The NFA was sustained as a revenue measure. The levy has vanished. Therefore, the constitutional basis for the NFA has vanished. What endures, they insist, isn't a revenue measure whatsoever. It is an unadulterated regulatory framework. It is a structure of enrollment demands, delay periods, background screenings, discretionary authorizations, and harsh criminal punishments for violations. And the litigants argue this structure cannot sustain itself without the revenue authority to bolster it. They have been reinforcing this claim with actual evidence demonstrating how the ATF manages the NFA in operation. And the portrait they sketch is uncomplimentary to the administration. They have submitted proof indicating that the ATF wields considerable discretion regarding how it handles petitions, that the structure doesn't operate like an impartial shall-issue system, and that the tangible impact of the NFA isn't revenue collection, but constraint and supervision. Put differently, the litigants are asserting that even prior to the levy disappearing, and the NFA was already functioning more like a regulatory prohibition than a revenue-gathering system. Now that the levy is essentially nil, the disguise has completely dropped. But this is where the litigation took a striking twist. The litigants didn't halt with their initial claims. They submitted what is termed a notice of supplemental authority, which represents a method for parties in litigation to alert the court to fresh judicial developments. And the fresh development they highlighted was a Supreme Court ruling issued earlier this year in a matter titled Learning Resources versus Trump. The litigants argue that this judgment strengthens a rigid division between Congress's Revenue Authority and its Regulatory Powers Act, would forbid the vending, transfer, fabrication, and ownership of firearm silencers. It's scandalous that they would expend $1.4 billion to render silencers more affordable. Some modifications have been implemented to the substantial levy, and encompassing ones that would relax regulations on firearm silencers. It has everything to do with generating profits for a specific portion of the firearm sector. The reasoning proceeds thus: if the Supreme Court is establishing distinct boundaries between what qualifies as a levy and what qualifies as regulation, then a statute that was defended exclusively as a revenue measure cannot merely convert into a regulatory framework when the levy vanishes. The NFA was marketed to the courts as a revenue measure. The levy is gone. And under this fresh Supreme Court reasoning, the litigants argue you cannot merely substitute a different constitutional rationale retroactively. The statute must stand or collapse based on the authority employed to enact it. This represented a daring tactical maneuver by the litigants, because it elevated the contention from a limited challenge regarding how the NFA is administered to an essential constitutional inquiry about whether the statute can even continue existing. And now, the administration has formally replied, and their reply is extraordinarily illuminating. The Department of Justice submitted a comprehensive rebuttal to the litigants' supplemental authority, and they are resisting vigorously on every front. Their reply informs us not merely what they believe about this specific argument, but how they intend to safeguard the NFA for the coming years. And their approach comprises several separate tiers. The initial tier of the administration's defense concerns relevance. The DOJ contends that the Supreme Court matter the litigant referenced bears absolutely no relation to the NFA challenge. They observe that Learning Resources versus Trump addressed an entirely distinct legal inquiry, specifically whether Congress had appropriately delegated tariff authority under a specific statute. The examination in that matter, according to the DOJ, concerned statutory interpretation and delegation of authority, not regarding Congress's constitutional power to regulate firearms. So, the administration's opening maneuver is to inform the court that the litigants are importing reasoning from a wholly unrelated context, and that the court should dismiss the reference entirely. The second tier penetrates deeper and assaults the litigants' foundational assumption. The litigants claimed there exists a rigid constitutional barrier between levying and regulating, and that the Supreme Court's recent judgment reinforces that barrier. The DOJ categorically repudiates this portrayal. They contend that the Supreme Court didn't establish any inflexible boundary between Congress's separate enumerated authorities. They argue that the Constitution doesn't demand Congress select a solitary authority when it enacts legislation, and that Congress has perpetually been at liberty to depend on multiple constitutional authorities concurrently. And this leads directly to the third and most significant tier of the administration's defense. This is the argument that alters the complete character of the litigation moving forward. The DOJ is now expressly contending that the NFA was never founded exclusively on the Revenue Authority. They assert that when Congress enacted the NFA in 1934, it was exercising both its revenue authority and its authority under the Commerce Clause. The Commerce Clause grants Congress extensive power to regulate interstate trade, and the administration is arguing that firearm regulation falls directly within that power. So even if the revenue component has been diminished to zero, even if the revenue authority justification has eroded or vanished, the DOJ states the NFA can still endure as a legitimate use of Commerce Clause authority. The statute always possessed a twin objective, they argue. It was always concerned with both revenue and regulation, and because the regulatory objective remains unbroken, the statute stands irrespective of what occurred to the levy. The DOJ additionally presents a procedural argument regarding judicial frameworks. They argue that the litigants are employing the incorrect analytical instrument for this matter. The Supreme Court judgment that the litigant referenced involved what is recognized as the major questions doctrine, which is a judicial principle employed to interpret ambiguous statutes. But in this matter, the court isn't interpreting an ambiguous statute. The court is confronting a direct constitutional challenge to an act of Congress, according to the DOJ. Those are fundamentally distinct categories of judicial examination, and the framework from the Supreme Court matter simply doesn't apply here. So now let's pause and examine the complete panorama of what is transpiring in this litigation, because the dividing lines are now exceptionally distinct. On one flank, the litigants are presenting a concentrated, precise argument. The NFA was rationalized as a revenue measure. The levy is presently zero. The statute has forfeited its constitutional groundwork. A fresh Supreme Court ruling upholds the principle that you cannot merely exchange a revenue authority justification for a regulatory authority justification. After the fact, the NFA ought to collapse on the opposing flank. The administration is presenting a sweeping, expansive argument. The NFA was never merely a revenue measure. It was always buttressed by multiple constitutional authorities. Congress can depend on both the Revenue Authority and the Commerce Clause simultaneously. The reduction of the levy to zero doesn't eradicate the Commerce Clause foundation for the statute. The Supreme Court matter the litigant referenced is irrelevant, and the analytical framework the litigants are employing is inappropriate for this category of challenge. This generates an essential collision that the court must now settle, and the result hinges on which interpretation of the NFA the court embraces. If the court concurs with the litigants that the NFA was historically rationalized as a revenue measure, and that the levy represents the sole element that rendered it constitutional, then the $0 levy modification could be devastating to the entire statute. But if the court concurs with the DOJ that the NFA has always rested upon multiple constitutional foundations, then the statute could endure even without a functioning levy. And this isn't merely a theoretical inquiry. The stakes here are immense. If the NFA collapses or is substantially weakened, it would revolutionize the legal terrain for silencers, short-barreled rifles, short-barreled shotguns, and other presently restricted objects across the whole nation. If the NFA endures by shifting to a Commerce Clause justification, it would establish a precedent that could render the statute even more difficult to challenge going forward, because the Commerce Clause represents one of the most extensive authorities Congress holds. What renders this moment so pivotal is that the administration's reply exposes their enduring strategy. They aren't conceding anything regarding the levy matter. They aren't retreating on any front. Rather, they are broadening their defense. They are erecting a stronghold around the NFA by arguing that it possesses multiple constitutional supports, so that even if one support is eliminated, the others maintain the structure upright. This is a purposeful and calculated method, and it signals that the administration regards this challenge as a legitimate menace. You don't deploy this variety of multi-tiered defense unless you believe the opposition has delivered some genuine hits. The subsequent major development will arrive when the court issues its ruling on the competing summary judgment motions. Both factions believe they should prevail without even proceeding to trial, and the court will need to determine whether the NFA's constitutional foundation remains sound or whether it has been fatally compromised by the elimination of the levy. Every component of this puzzle carries significance. The historical documentation of why the NFA was enacted, the judicial reasoning courts have employed to sustain it for generations, the tangible reality of how the structure functions currently, the implications of the $0 levy, and the relevance of fresh Supreme Court precedent. All of these strands are now interwoven into a solitary matter that could reconfigure firearm law in America. This narrative is far from concluded. The court has received arguments from both factions, and a ruling could arrive at any moment. When it does, the repercussions will be sensed across every state, every firearm establishment, and every firearm owner who has ever maneuvered through the NFA structure, whether the NFA stands, collapses, or is compelled to evolve into something wholly different. The resolution is approaching, and based on what both factions have now placed on the table, the court possesses everything required to render that determination. That's it for today, folks. See you in the next video.